As you may be aware, several of my blogs in recent years have dealt with mediations. Mediations are increasingly used, as is all forms of alternative dispute resolution. I find it almost remarkable how commonplace mediation is in a major civil case and a major personal injury case, as compared with when I started practicing law more than 30 years ago. I used to be a mediation skeptic, having felt that it's only as good as the amount of money that is brought into the mediation. But I've seen it be successful over so many cases that I am now very much in favor of mediation. You hear what the other side has to say, what their evidence will be in a case, and you hear usually what will be their best offer at that time, and you and your client can make an informed decision as to what to do. One thing that should be borne in mind is that Massachusetts operates under a mediation statute. It's Chapter 233, Section 23C of the General Laws. And basically that law tells us, that statute tells us, that a mediation process is to be confidential. Not only will the mediator's case file be confidential, but communications made in the course of the mediation are to be held in confidence. And this law has been reinforced by some decisions in Massachusetts which grant a blanket confidentiality to the whole mediation process. Now, confidentiality is something that, of course, I think most people are familiar with, and it is an essential part of our legal doctrine. There is a priest-penitent confidentiality, a husband and wife confidentiality that in fact can be referred to as a spousal disqualification. There's certainly a very common one is known as the attorney-client privilege or confidentiality. So the fact that mediation is afforded a confidentiality status is not very surprising. And the purpose, I would suppose, is to encourage a free discussion and to encourage settlement with neither party worrying about it being used against them. I will continue to be a proponent of mediation until I see otherwise. It is used now along with arbitrations and case evaluations and so forth. And in fact, in the court's pretrial order, they want to know about the parties' position on alternative forms of resolution. So when you go into a mediation, you need not fear that something you say can or will be used against you. You have a complete assurance of confidentiality, and that is something that I think has contributed to the success of mediations in Massachusetts, in the personal injury field, in especially the past decade. Thank you very much.